right, very happy to be here with you. My name is Ali Talai, and today I'd like to share with you some ideas about estate planning when it comes to estate planning for minor children when you are a single parent. It is essential to make sure you have a customized and comprehensive estate plan in place to take care of your younger children. To tell you a little bit more about myself, Ali Talai. I'm an attorney. I'm a estate planning attorney. I have an advanced tax degree, and my practice here in Woodland Hills, California, really focuses on estate planning, all aspects of it, how to avoid probate, how to do planning to provide for our younger children, guardianship, incapacity, asset protection, estate tax planning, trust administration, probate. So anything related realistically with estate planning we do. If you're watching this video on YouTube, please go ahead and give me a like, and you can subscribe to our channel as well. We do have other videos on other platforms like Instagram and LinkedIn. Please subscribe there as well. And I hope today's webinar will be helpful to you. Let's talk about estate planning for minor children. Obviously, if you have a minor child, they are depending on you to take care of them. And the goal here is to make sure you have an estate plan in place so that if you're not here, if you are incapacitated, there is some sort of plan that provides for their care and what needs to be done. That's why this estate planning when you have minor children becomes so essential. The first part of estate planning and thinking about these sort of plans when we're talking about minor children, we want to make sure our plan has instructions and points who's going to care for them and how are they going to care for them. So let's go through that. Naming guardian, obviously that is the first thing to make sure we have in place if we have children that are under the age of majority. In California is 18. We want to know who's going to be able to raise them. As you know, minors cannot raise themselves. And so this becomes important that we have somebody named as a guardian for our children. If the other parent is alive, they're going to be able to care for them. As long as they're alive, they can care for the child and they're deemed to be fit to care for the child. That's an option. By planning ahead, you can choose who could care for your child in case you and the other parent is not able to care for the child. Instead of having leave that open to a judge that doesn't really know you, doesn't really know the family dynamic, and having them pick someone. So we definitely want to make sure we pick a legal guardian for our child. And so the question becomes, well, how do I do that? Naming a legal guardian or nominating a legal guardian can be done by last will and testament. It's written in there, and you talk about who could be nominated to take care of your child if that situation does come up. One thing you want to keep in mind is that when you name or nominate a guardian in your last will and testament, in your pour over will, just the way they work, just by their nature, they are going to be effective at the time you've unfortunately passed away. So if you become incapacitated, a will is not at a stage that would be effective. So having you name a legal guardian or nominating a legal guardian for your child in a will could be problematic if unfortunately, you have not passed away, but you don't have the ability to make decisions. So it's really important to make sure that we do have a will that names a legal guardian, but we also want to have a separate document that takes care of who's this person, who you're nominating to be the legal guardian in case you're incapacitated and don't have the ability to make mental incapacity is at issue, not so much physical incapacity. And so it's really huge to make sure you have this separate document that allows you to name temporary guardian. I'm sorry, legal guardian in case you're incapacitated. The temporary guardian becomes really essential if the person you want to care for your child is far away. So if you live in California and you have your parents in New York, if something were to happen to you, your parents wouldn't be able to get to California within an hour. So we want to make sure we have a temporary guardian, someone that is very close to you, a close friend, a good neighbor, someone that you trust, and you could name them as a temporary guardian. So we want to name a guardian in your will. We want to have a separate document that names a guardian if you're unable to make decisions. And then we also, if necessary, we want to make sure we have temporary guardian named in a separate document that could take care of your child until the permanent guardian gets there. All right, so now let's talk about how we could handle their inheritance and what sort of planning could be done. Obviously, again, as a minor child is not able to take care of their finances. And what happens a lot of times is that the other parent may be chosen to manage the money and take care of everything that you are going to leave for your child. And a lot of time that becomes a big concern for parents because for one reason or another, they don't like the other parent to be involved. And so now if you don't do any estate planning, that means they're going to be involved and they're going to really have access to all your asset at the time the asset is being passed along to your child. And if you get to choose, if you do this while you're alive, you're going to eliminate the court having the power to now appoint somebody to take care of the finances and those sort of things. Let's talk about receiving inheritance. So if there is really no plan in place, if you didn't do a trust or maybe just a will-based plan or didn't have a plan, in most cases what happens that the child receives their inheritance outright at age majority. Again, here in California it's 18, and as you could probably agree with me that in most cases having an 18-year-old inherit 100,000, 500, a million, whatever it is, in many cases more than that, might not be the best decision. It may not be, productive for them to inherit all this money, and they could do whatever they want to do. They may not want to pursue their schooling. They may not want to pursue, their work in different things that they're doing, or we want them to do. So obviously, we want to make sure we have some sort of plan in place. If you have a trust and you set up a plan through estate planning, through a trust-based estate plan, like a revocable living trust, then in that case, then you could indicate how they would receive the money. You could create continuing trust for them. So now the assets are left within a trust that would provide them asset protection in the future. There's really two kinds of trust you could do. You could do testamentary trust, and these are really trusts that are created at the time you pass away. It's usually written in a will that at the time the person passes away, the asset goes into a trust. The other one, they call it inter vivos trust, revocable living trust, something that you create at the time you're alive that would fall under this inter vivos trust. And it just means that that's a trust that is created now at the time you're alive. And again, when we do these trusts, the idea is that you would put a plan in place that would avoid probate. So now you do it now, you transfer your asset, you connect your asset to it somehow, depending on the type of asset. And then at the time you're not here, the trust has instructions, it's alive, it'll do everything, it'll avoid probate. We don't have to have this 1.5-year probate process and the expenses and all that stuff that is associated with it. And we could do, guardianship planning in there, incapacity planning. You could do all these great things. Versus a testamentary trust, which you have to create under a will, it just doesn't make a whole lot of sense because it means you still have to go see a lawyer or you're going to write your own will. But the whole goal of doing a trust in many cases is that we want to do something that we avoid going to probate. So now if you create a trust under your will, it means your child or whoever is handling the estate would have to go to court to administer the will, and then in the will there's a trust, and then now the trust will be created. So we're just asking for a lot more work. It's much better to create your trust now when you're alive versus trying to create it after you've passed away through your will. Okay. Distribution options. So when you set up a trust, you could set it up that all the asset that is in the trust is distributed to the child at a specific age. It could be a percentage at a specific ages. And the other option, which is in most cases my favorite option, and I think it's probably a better option, is that we don't have any outright distribution, no age, no nothing. And the reason is, who knows what's happening to the child in his or her life at age 25, 30. I mean, they might be going through a divorce. They may be going through a lawsuit. And the last thing they would want is that a trust that terminates and now they get, X amount of dollars in distributions, because now that distribution could be susceptible to creditor attachment. And so in my view, in the way I like to set up these trusts, I like to set them up that at certain age, we would say the beneficiary becomes the trustee of his or her own trust. So now reality of it is that if they need a larger distribution, they're in charge. They could make distributions. But if at some point there is some sort of issue, there is some sort of lawsuit that they're dealing with and they don't want any distribution, there's nothing in the trust that says they must or shall take any distributions, and there's an option for them to even resign as the trustee of the trust to sort of further themselves from the trust and distributions from it. Obviously, with a trust-based estate plan, we could do a much better estate planning for the beneficiary. It could provide them asset protection. It could provide them estate tax planning, and many, many more things within the trust. Obviously, when we have a trust in place, there's going to be this person that is going to manage the trust. They call that person the trustee. Usually with a revocable living trust, when you create it, you're the grantor, meaning the person that created the trust. Then we have this trustee who's the manager of the trust. And again, when you create it, in most cases, people are the trustee of the trust. So they become the current trustee of the trust. And then we need to select successor trustees. And we're going to talk about, suggestion of who you would want to choose. But the other player within the trust is a beneficiary. And in many cases, people think that when we're talking about a beneficiary, it's their children. And they're correct to a certain degree. Our children, or who we name as a beneficiary at the time we're not here, they are a future beneficiary. So if I create a revocable living trust, I'm the creator, I'm the manager, and I'm the current beneficiary of my trust. It's not my child. They're not the beneficiary. I got to say goodbye. And then after that, they're going to be the beneficiary of the trust. And this becomes important because sometimes individuals that are setting these kind of trusts, they think, well, if I name my child, does that mean I don't have any power anymore? What happens if my child is going through a divorce? Does that mean their spouse could attach the assets that are inside of the trust? What happens if they're going through a lawsuit? Can they attach the assets that are inside of my trust? And the answer to all those is no, because your child doesn't have any ownership. This is contingent on you not being here. It's at that point that they could become the current beneficiary. And again, if the trust is drafted correctly, it still would provide a great deal of asset protection against a divorcing spouse, against a creditor that might be coming in and trying to attach asset of the beneficiary. All right, suggestion for choosing a trustee. Obviously, whoever you choose as a trustee, it has to be a person that you trust. It has to be a person that is detail-oriented. They can follow directions. They're not afraid of asking questions. That's the kind of person you want. And it could be a family member, it could be a close friend, or there are professional trustees. There are companies that all they do, they serve as professional trustees. Great thing about them is that they're going to do what the document says, it has to be done. They know what they're doing. They have a lot of experience. So those are all the great things. A lot of that's what a lot of time people would end up choosing them if they're going that route of having somebody beside a family or a friend. Negative is that they don't really know you. They don't really know the family dynamic and things like that. So that sometimes become an issue. and people rather have family members, close friends. And again, if I'm naming my own child and at some point he or she is, older, or my children are older, if there's really nothing else, no other reason that I may want to look at a third party, then I may just name them as the successor trustee. The successor trustees are usually sections within the trust that would have to be updated every so often, because sometimes people just, say they don't want to serve anymore, or they obviously maybe they've passed away, or, a situation like that. So then it would be updated. All right. I think that's it. I hope you enjoyed this video about estate planning. If you're if you have minor children and you're a single parent, please share this video with a friend or someone that that is looking to do some estate planning. Maybe they're a single parent and they have a child and they want to get some more information. If you'd like to get in contact with me, we could always go to our website and make a 15-minute call with me free of charge, and I'll be more than happy to jump on the phone with you and talk about your estate plan and see what I can do to help you and your family. All right, take care. Bye-bye.